Aru's little towels. Good evening. I have a huge headache. So for anyone on the replay, this will mean nothing. For anyone not on the replay, which everyone's like coming in, this means a little shorter today. Well, a lot shorter than yesterday. Yesterday, I think we were what 3 hours or something. But plan is to kind of keep this to 1 hour, 9:30 at best. I brought my standing desk so I can finally not have you in weird positions. Um, and yeah, if anyone knows how in the world to connect the Sony A6400 Alpha to a MacBook for this, because for some reason I'm following the instructions and it's not working. But anyways, all right. So today for this video, again, keep it very short. There's a new lawsuit. Everyone probably already knows by now, maybe not. It was hard to find, but I think I found how people are finding this. Before the lawsuit, though, I'll say like another piece of news is, I guess, another simple favor. Always want to say another or a simple flavor because it's just rolling off the tongue that way. Tachukuroshu. Me? No? That one is the sequel, I think. Another simple flavor. I almost want to say not quite as creative, are we? But it was supposed to be coming out in March, right? In theaters, or they were supposed to be doing press, all that stuff. They're losing out because of this lawsuit. So, she might Blake Lively might not be losing out that much, but she's still losing out on a lot. And but I mean, as far as like becoming a liability. And I guess I found this because I was searching for this Jed Wallace lawsuit. I found this little tidbit that she's supposed to be heading to South by Southwest next month in Austin for the debut of another simple favor. But the actress's lawyers are exiting Texas when it comes what to her and Ryan Reynolds' multifarious showdown with Justin Baldoni. What do you mean exiting Texas? Okay. Anyways, I don't know. That was from, I think, the Hollywood Reporter. So we'll see if she's and how that will go, South by Southwest, and this another simple favor. But anyways, I did find the Judd Wallace lawsuit. It's a short one. It's only 10 pages. It's only 10 pages. Not sure that I'll be reading too much of it, but I did find it, and I'm curious to, especially because the media articles with all the ads and everything and pop-ups, and this is also straight to the source. So Jed Wallace was the guy that they hired, that Melissa Nathan, I think, tag team wise, they hired him like as a, like, we need a third crisis PR manager or person, and it's kind of left on dubious terms as far as like, did he plant anything? He has been basically referred to, and I kind of understand because there was a comment in my research saying, oh, being part of a lawsuit is not defamation. However, there was like this in the article, I think, in a New York Times article, and even, just the aura of how he's part of this was definitely like hinting that he was doing some really, I guess the word nefarious is applicable here, things that he was actually planting, and he was like this kind of like Batman, like no one sees him. He's in the shadows and doing all the stuff. So I guess he got tired of that. He's losing probably his own clients, or not clients, but potential clients, or both. And so he decided to sue Blake Lively as well in a civil action. I guess this went straight to the lawsuit part. Complaint for declaratory judgment and defamation to the Honorable Court, Jed Wallace and Street Relations Inc., further known as Wallace and Street, collectively plaintiffs, bring this action for declaratory judgment and defamation against Blake Lively, further known as Lively or defendant, and would show as follows. The parties: Wallace is a citizen of Texas and resides within the Austin division of the Western District. So is this filed? Yeah, it is filed in the Western District of Texas, Austin. Okay. I wonder how that will play. How that will play for things with New York. Will he get adopted into the big one, or like Flubber? this this lawsuit is like Flubber. It just keeps like growing. I don't know. Anyways, or will it stay separate? So he owns a company, Street Relations Inc., which is a crisis mitigation firm engaged by clients to help navigate real life human crisis, threats, trauma, and mental health concerns. Interesting. It helps primarily families and individuals when they find themselves unjustly attacked, extorted, doxxed, swatted, scammed, or need help navigating through the most frightening situations. I want to say, not to like, this was heavy to read, not to like completely lighten, but when I read doxed, don't know what that means. I think the new drinking game is whenever there's a word that you've not like seen before, and for me, like drinking water, because I don't drink water and take a breath. All right. So that is that is different, right? He's not saying that he's like a celebrity crisis manager. It's interesting. I wonder if he is, and they just kind of phrase it differently. Street is a corporation organized under the laws of the state of California with its principal place of business in Texas, and is therefore a citizen of a state other than New York. Lively is an actress and entrepreneur and is a citizen of New York. This already feels like a lot more professional, a lot more like just standard. Factual back, and I've never read a lawsuit in my life before all of this, by the way. So I don't know what I'm saying. Maybe that's not true. Factual background. So on December 20th, 2024, Lively filed a complaint of employment discrimination before the state of California Civil Rights Department, CRD complaint. The CRD named Lively as complaint and Wallace as street. Okay, among others, as respondents, and alleged that they engaged in a variety of conduct in violation of California Government Code Section 12940, the FEHA, and Title 7 of the Civil Rights Act of 1964, further known as Title 4. FIHA, really? I don't know if people pronounce it that way, but anyways, the CRD complaint went on to allege that plaintiffs' conduct includes retaliation, failure to investigate, prevent, and/or remedy harassment, aiding and abetting harassment and retaliation. Exhibit 1 CRD complaint attached hereto and incorporated herein. The CRD complaint also asked politely to please see attached complaint for specific details. The attached complaint, which we attach in and incorporate as Exhibit 2, has been described as a precursor to a lawsuit, although it had all the indicia. Oh, okay. Indicia, like indicament of a standalone legal complaint. I guess I should drink my water. Indeed, some media subsequently published the precursor precursor under the headline. I'm so sorry. Read the complaint. The precursor named Wallace and Street as defendants and sought damages for 1. SH under California federal law, 2. Retaliation under California and federal law, 3. Failure to investigate, prevent, and/or remedy harassment under California law, 4. Retaliation under the California Labor Code, 5. Aiding and abetting harassment and retaliation under California law, 6. Breach of contract, 7. Intentional infliction of emotional distress, intentional, 8. Negligence, 9. False light invasion of privacy under the California Constitution, and 10. Interference with prospective economic advantage. On the same day, the complaint with the precursor attached was filed December 2024. The Civil Rights Department issued Lively a right to sue letter. See Exhibit 3, attached here to, incorporated herein. Lively or her agents provided the precursor to various media entities for out of court republication, and because of the allegations contained therein, it made headlines around the world. According to Elle magazine, Elle entering all of this, bringing in a new one because we needed that. Another party. According to Elle magazine, which linked to the precursor document, as did many other media, see Exhibit 4, attached here to and incorporated herein. The precursor was followed on or about December 31st, 2024, by a formal lawsuit in the United States District Court of the Southern District of New York. Wallace and Street were widely reported to be defendants in the formal lawsuit, although they were not, and the confusion having been sown by the precursor. As Lively later admitted, she knew of no facts to support the allegations against Wallace or Street. Indeed, having been the one harassed, she knew the exact opposite. Neither Wallace nor Street had anything to do with the alleged SH, retaliation, failure to investigate, or aiding and abetting that the alleged harassment or alleged retaliation. Neither could they have breached a contract with Lively because no such contract exists. And they were not involved in any of the events depicted in either the precursor, where they were named as defendants, or the formal lawsuit, where they were not named, which could give rise to a duty toward defendant negligence or any other tortious conduct, false light, intentional infliction of emotional distress, or interference with prospective economic advantage. Then on January 21st, 2025, Lively filed her verified petition for Rule 2202 deposition. And oh, sorry, in Hayes County, Texas, against Wallace, but not Street. Oh, we didn't know this one. Alleging on information and belief that Wallace was a subcontractor to a company called Tag to assist them in their unlawful retaliatory social combat campaign against Lively. The 202 petition or 202 petition conceded that Lively has no facts supporting the allegations she made against Wallace and Street in the precursor, which made headlines around the world, as she now, apparently under the threat of sanctions from one of plaintiff's attorneys, sought to investigate the scope of Mr. Wallace's conduct. That is that is an interesting that's new and that's interesting. I that's so weird. But, yeah, hold on one second. Um, sorry for the replay. Alright. Continuing on. According to the Hayes County Online, so she started it because people are saying, "Oh, she's being sued again," but it sounds like she started it with this verified petition for Rule 202 deposition. Well, I guess it's not started it, but bringing him in for sure into the lawsuit, right? Because this means that she is asking for him to be deposed, right? Don't know. Don't know. This is a very good question, or maybe a stupid question. It's a question I have. According to the Hayes County online court records, Lively non-suited her 202 petition today. The 202 petition, and I'm sorry if I'm not reading that right. The 202 petition was a transparent attempt to chill plaintiffs' free speech rights and would have been fodder for a motion to dismiss under the Texas Citizen Participation Act, Chapter 27, Texas Civil Practice and Remedies Code, anti SLAP statute, whose purpose is to encourage and safeguard the right of persons to speak freely. Huh. Um, that's interesting. What is this 202 petition? So, and I should include that this hold on, because I feel like I'm getting a little confused with this. And let's go to Google. So Google says, um according to, I guess, this site, this rule allows a person or party involved in a dispute to request deposition, sworn testimony recorded by a court reporter, to investigate a potential claim before, filing a lawsuit, or obtain testimony in anticipation of a lawsuit. Wait, but how is this chilling his free right or free speech rights? A person may petition the court for an order authorizing the taking. Oh, hmm. Is it because maybe they say, maybe they continue to say the main part. The statements of fact, actual or implied, of and concerning plaintiffs in the persecutor and CRD complaint are false, defamatory, made with either negligence or actual malice, and have caused millions of dollars in reputational harm, including both general and special damages through emotional harm to Wallace, actual damages, and real and projected loss of business to Wallace and his PR business street, in an amount that exceeds $1 million. So, number two, the jurisdiction and venue. This court has jurisdiction under 28 USC 1332 because the matter exceeds the sum or value of 75,000 exclusive of interest and costs, and Wallace and Street as plaintiffs are not citizens of the same state as the sole defendant, Lively. This court makes exercise personal jurisdiction over Lively because she has availed herself of the forum by filing a Rule 202 petition in Texas on the subject matter of this suit. So we're involving a. It sounds like, yeah, we're involving a whole different state. Um, C. Payne Weber Inc. versus Chase Manhattan Private or Privacy or something Priv Bank Switzerland, noting the well established rule that parties who choose to litigate actively on the merits thereby surrender any jurisdictional objections. Okay. Holding, and then see also Halliburton Energy Services Inc. versus Iron Shore Specialty Insurance Company or something. Hold this to say holding there was no personal jurisdiction because defendant never initiated an original action in Texas, which would have subjected it to personal jurisdiction. This is so much more confusing because this is so much more, I feel, legal language and less for the public, which therefore the CRD complaint that Blake Lively files looks even more so meant for the public. Because it was not like this. It was storytelling. It was, she included the screenshots and stuff. Um, yeah, starting to understand the lawyers that say that was too much. In addition, her defamatory statements were aimed at Texas, where both plaintiffs reside, and they undoubtedly caused harm in Texas. Number 16, venue is proper because, as Lively alleges in her Rule 202 petition, quote, a substantial part of the underlying events that would give rise to the claims being investigated occurred in Hays County, part of the Austin Division of the Western District of Texas. See in Re Blake Lively case number 2025-25-0200 DC, Hays County, January 21, 2025. In addition, a defamation plaintiff is accorded great deference in his choice of forum, especially when it is his home venue where the defamation is most keenly felt. That meets the standard for venue under the venue statute. First cause of action. Wow, this is straight to the point. This is what they kept saying. First cause of action, Declaratory Judgment Act. The Declaratory Judgment Act allows a court to conclusively adjudicate and declare the rights and other legal relations of any interested party seeking such declaration. The purpose of the Declaratory Judgment Act is to afford one threatened with liability an early adjudication without waiting until his adversary should see fit to begin an action after the damage has occurred. Rowan Companies Inc. versus Griffin. The Fifth Circuit has long recognized the validity of such anticipatory declaratory judgment actions. See Casper Wire Works Inc. versus Lico Engineering and Mock Inc. The plaintiff, in an anticipatory declaratory proceeding, is seeking the adjudication of an issue that would arise in a conventional proceeding brought by the defendant. And the Fifth Circuit continues to recognize the issue preclusive effect of such anticipatory declaratory judgment suits. That's like fun to say, anticipatory declaratory. This is Asarco LLC versus Montana Residence LLC or Inc. Inc. I don't know. As explained above, Miss Lively has alleged 10 different causes of action against Wallace and or Street, although she now admits that the CRD complaint and the precursor, which caused great harm to plaintiffs' business by way of lost business, exceeding the threshold monetary limits necessary for diversity jurisdiction, as it was reported around the world, was without factual support, even though she now belatedly attempts to obtain some through her 202 petition. This claim is justiciable, and the court has authority to grant the relief plaintiffs seek, which is that they did not breach any contract with defendant for the reason that, among others, no such contract exists. They did not engage in any acts of harassment, retaliation, failure to investigate. Oh, isn't that like the New York Times failure to investigate? I don't know. Prevent and or remedy harassment or aid and abet the alleged harassment or retaliation for the reason, among others, that they were not even present or otherwise involved in the events giving rise to the alleged harassment, nor did they have contemporaneous knowledge of the alleged events of harassment or retaliation. Also, they did not have a duty to defendant, which would give rise to a claim for negligence, and they did not engage in any tortious conduct towards the defendant. Plaintiffs seek a declaration pursuant to 28 USC section 2201, second cause of action, defamation. The precursor and CRD complaint named Wallace and Street as defendants or respondents and falsely stated that they had engaged in 10 illegal acts under state and federal law. Neither the precursor nor the CRD complaint were privileged because, among other reasons, they were provided by the defendant or her agents to third parties, including many media outlets. Defendant knew or should have reasonably anticipated, indeed she hoped, that these allegations would be republished around the world. As a result, defendant is responsible for republication damages. The statements of fact of and concerning plaintiffs in the precursor are false and defamatory. They are made either negligently if plaintiffs are private figures, which they are, or with actual malice if plaintiffs are public figures, which they are not. The statements have caused, both by the original publications and the publications around the world, great harm, I guess like us too, great harm to plaintiffs, and such damages are presumed if some or all of the statements are defamatory per se, or per quad, if not per se. And in any event, I'm gonna refrain from the water drinking because my stomach hurts right now. And in any event, exceed $1 million. In considering whether the $75,000 jurisdictional amount has been reached, the court can take notice that many recent awards, Freeman and Moss versus Giuliani, $148 million, or settlements, Dominion versus Fox or slash Fox, $787 million. Trump versus ABC, $15 million, far exceed that amount. Although Lively is a public figure, Wallace and Street are not. Thus, plaintiffs need prove only negligence to establish liability. However, plaintiffs also seek punitive damages in an amount of not less than $6 million, and to satisfy the evidentiary burden in establishing the right to such damages, they must demonstrate actual malice. That is, that Lively either knew the allegations were false at the time she made them, or she acted in reckless disregard of the truth. That if she had a high no that she had a high degree of awareness or of falsity, and in fact entertained serious doubt about their truth. She acted with actual malice because she was the one claiming to have been harassed and retaliated against. She was the one who claimed that she had a contract with plaintiffs, and yet there is no such contract, and plaintiffs were nowhere near where the alleged harassment and retaliation took place. But it's online. Lively knew this, and it is not the case that she was harassed by some masked stranger who turned out to be the plaintiffs. She knew and knows that they were not the harassers, retaliators, but made these allegations anyway. That is an important one, I would think. Leak them to the press, hoping they would be widely republished, which they were, but then excluded plaintiffs from the formal lawsuit, knowing they had nothing to do with the events depicted therein. That is interesting. That is interesting. Excuse me. Wow, almost done. Um, and number nine, jury demand. Plaintiffs under Federal Rule of Civil Procedure 38 demand a jury. And the prayer being plaintiffs therefore respectfully request that this court to enter a final declaratory judgment under, 28 USC 2201 as requested, supra, and award damages for plaintiffs' loss of reputation and for further relief at law or in equity as to which plaintiffs may be entitled. Respectfully submitted by Jackson Walker LLP. This was submitted yesterday. So, um, I know most of you will watch in replay. So, comment below what you took from this. It sounds like this is depends on, I guess, her action to this, which probably I take that back. It's probably not going to be a short one, but it sounds like pretty short and to like straight to the fact. Um, yeah, right? Especially at the end, although they asked for a jury. It sounds like, hey, we just want our damages paid. And I don't see anywhere where they're asking, hey, can you take us out of your original complaint? Is that something that would be included in a lawsuit or a complaint? I don't know. But those were like the two tidbits, and my stomach is really, really hurting. So I was going to go for 9 o'clock, and I guess there's not much going on. So I made the 9 o'clock. Just a quick one. I already made the reading earlier today. I finally finished the 168 pages, and tomorrow I have maybe like a video. I'm working on a little presentation, not PowerPoint, but that kind of presentation to accompany me on my next video or live. So stay tuned for that. Keep your eyes out for that or whatever. Um, and yeah, let me know your thoughts. Have a wonderful evening or day or night, dinner, lunch, breakfast, and I will see you hopefully tomorrow. Bye.